What are you doing this time?
No.
Happy Valentine's Day. Thank you.
Would you like to hear the recital? As I sit in this here, Paris, I'm dreaming of you.
Oh my God.
What's my spirit?
Oh, yeah. All right.
That is so true.
Two more.
Committee on Economic Development will come to order. Secretary as follows.
Here.
Barry.
Here.
Dunn.
Here.
Fitzwater.
Here.
Green.
Here.
Pryor.
Here.
Lane.
Here.
Miller. Heitzman.
Here.
Walker.
Here.
Rowland.
We have a quorum. We are going to open with hearing Representative White, House Bill 44. And I apologize, because you've had to come twice to present your bill, Representative. Please start whenever you're ready.
Thank you, Madam Chairman. My name is Bill White. I represent the 161st District. I'm bringing for you today House Bill 44. It's a bill I've had since 2011. It came about as a result of a tornado we had in Joplin. I would like to mention up front, I do have an amendment that I've supplied to the committee at request that pulls out the effect for my bill to only be in declared disaster zones. It just applies to all MHDC housing projects across the board. What the bill does, is a very short little bill, just says that notwithstanding the current things, any For any housing eligible for housing tax credit, the commission shall not require prevailing wage to be paid to any contractor for any work performed on such housing. That was the state of Missouri until 2010. Our prior governor, Governor Nixon, put that on through the MHDC committee in 2010. It came to a head because of our tornado and the other disasters we had around the state in 2011. What we discovered with our Joplin tornado was that prevailing wage on these projects has an impact. First of all, let me go through this, that this tax credits from the Missouri Housing Development Commission do not meet the definition of what is required to be prevailing wage. The governor did this because he can do that as the governor, the past governor. It does not qualify as a public works project in our Missouri codes. You look at the definition. It also, by the U.S. Supreme Court, tax credits are not considered a governmental expense because, of course, they come out before it ever gets revenue. So in neither of the two components really does it qualify for prevailing wage. It is not a government expense and is definitely not a public works project. This really got highlighted in Joplin because when they put out bids for our MHDC housing requests, which, by the way, we had about, I don't know, I can't remember, about 6,000 plus housing units that were destroyed or damaged. We had a lot of need for low-income housing. The tornado itself actually drew a line. It couldn't have gotten rid of our older turn-of-the-century kind of housing that was our low-income housing. It would have been hard to draw a better path to take out most of that. But I had people, we submitted bids. They gave us information to write letters. And one of the things I'm concerned about is the quality of housing. I'm kind of a green Republican, so I gave them a list of questions. I wanted to know things like the value of their windows, the insulation, the air infiltration issues, which they answered. They submitted their bids, we wrote our supporting letters, and all of a sudden MHDC became aware that they had used an older, incorrect prevailing wage rate. And so they were given a month to refile. Well, just going from a lower prevailing wage rate to the current one that was in effect in 2011, all those projects were resubmitted, they were redesigned. We had housing that went from 2 to 6 wall construction to 2 to 4 wall construction. We had insulated values drop. We had things that went from single family housing projects were now put down into duplexes and quadplexes. We had duplex and quadplexes became apartments. We had some that just didn't refile. Basically what this did to us by just using a current prevailing wage from a lower prevailing wage, but upping the cost of the wage to do these housing projects cost us both quantity and quality in low-income housing. Low-income housing is not low-income housing if it's not energy efficient. And what I saw as a result of that having to refile was just an increase in the already required prevailing wage was devastating for what we got. As an example, this is still very important. We'll hear discussions. I'm sure someone will bring up the issue of, oh, well, we need to pay people wages. Well, this was not required until 2010, and housing projects, our construction in our town is our actual real prevailing wage, not the legal prevailing wage, the wage that we actually pay in the towns. That I've had some of my friends that work construction to do this, and they said to me, you know what? It's really nice we get this, but it's crazy because I'm paying my taxes. I'm doing the same job I would do with the same materials, the same types of projects, yet I'm getting a higher wage for it. And it's my tax dollars paying for it, and I'm not happy with it. So I think that's a component. We are still low in Joplin. We have 150 people, seniors, low-income seniors, on a waiting list at our Parkview low-income housing facility. The argument that, well, we need to do MHDC housing is low-income housing. We need, especially disasters, but in general, it's low-income housing. People need housing. And I put that as a higher priority over than an artificially inflated wage from our local people. Also, we've had several comments in the past about, well, it brings in foreign workers. Well, we had a lot of real prevailing wage work done in Joplin with our schools and things like that. And you know, those contractors, some of them were out of state, and they brought in their own out-of-state workers. The idea that requiring this type of residential construction to require prevailing wage is going to keep outside non-Missouri people from doing it is crazy. Prevailing wage does not prevent outside people from coming in and bidding or working on jobs, or contractors, subcontractors being brought in from out of state. It just determines the wage they're being paid. So that argument that we're going to keep our jobs local for Missouri and any prevailing wage, but in particular this, I don't think holds water. I would request that the committee favorably review this bill. Housing is critical. Low-income housing is critical. People that cannot afford a place to live, families, we're not just talking individuals here. This is how they can get acceptable housing, and particularly after disaster. As in Joplin, there is no place. Those houses that were built at the turn of the century, before the turn of the century, are gone. We still have people that live in Neosho that commute back and forth. It's a little town 10, 12 miles away from us. We still don't have an adequate amount of housing in our town. And the new housing is being built privately without the MHDC funding is beyond their reach for expenses. So I'd be happy to take any questions.
I have a question. First, then we'll get to you, Representative Dunn. So you said that it was changed in 2010, and you may have said this already. Was that by legislation?
No, that was
by...
a policy decision on the MHDC, Missouri Housing Development Commission, which there was one conservative on the board, Peter Kinder, and the rest of them were not. It was a decision made by them, not by statute.
Got it. Okay.
The prevailing wage, low-income housing tax credits do not qualify as the two components of public expenditure or public works projects. When you look at the definition of public works in our statute, it does not meet the definition. And the United States Supreme Court has clearly stated in multiple cases that tax credits are not to be considered, are not a government expense.
Interesting. Thank you. Representative Dunn. Proceed.
Good morning, Representative.
Good morning.
First of all, I just want to say a lot of what you said I agree with in terms of the need for additional low-income housing. There certainly is a need for that. Making sure that homes are retrofitted when it comes to keep utilities low. I certainly agree with all of those things that you said. Just a couple quick questions I have, and perhaps your amendment that you would have might answer some of these questions. I don't know. Do you know how many disaster areas have been declared over the last couple of years? I'm just trying to get an idea of how many counties or communities this would impact.
It varies year by year for the declarations. In 11, we had one, of course, in Joplin. St. Louis, I believe, had the disaster declaration. They had a tornado shortly after ours on the west side of town. We had one in Sedalia, I believe. We had the flooding issue along the Mississippi River. I believe we had 5 that year that were around. We may have had more. I'm aware of 5. We also had flooding on the Missouri up by St. Joe. So it was not just tornadoes, floods that year.
And then once the disaster area is declared, if this bill were to go into effect and prevailing wage would go away essentially in those communities, how long then after that declaration would this be in effect?
Those were questions we've had in the past. My amendment would do away with the requirement that it be a disaster zone. We just would get rid of it, get rid of the prevailing wage requirement on all MHDC housing and put it back where it was in 2011. My answer to that was it depends on the disaster. I would still like to have special consideration for Joplin. We still have a large amount of, a deficit in housing for low income in Joplin. I mean, and it's, 6 years later, and I would still like to have if there was a preference checkbox we could do, I would still put it on there. We're still recovering from that disaster for low income housing.
Yeah. So, and just so I can make sure I understand, so then as your amendment is drafted, we don't have that before us yet.
Right.
So I'm getting a little bit ahead of myself. But as that language is drafted, then once, if this were to go into an effect in an area, then as it stands now, then it would be for perpetuity. Well,
I would not say perpetuity. I think when you don't have a definition, you go into a reasonableness factor here. I think a disaster the size of Joplin, I think several years would be a reasonable thing for the commission to do that, to make that determination when it is no longer, when the housing requests are no longer related to a disaster. Sedalia had a much smaller impact on it. It was a much smaller tornado, limited area. 1 year may have sufficed for that. Disasters are not the same. And there's only a limited amount of MHDC housing tax credits given out each year. And very rightly so, it isn't, even though we had a terrible disaster, and there were still other MHDC grants given all over the state because there's still needs for low-income housing across the board. And well, I think we got a pretty nice share of it that first year. It would have been nice to have all of it for my people, but I appreciate why it didn't come to just us. So you know, a small disaster, 1 year is appropriate. A really large disaster like Joplin, 1 year would not be appropriate. So it doesn't have a definite fixed time on the line.
Well, thank you, and I'll probably reserve any other question I have for when we have the amendment before us. Thank you, Madam Chair.
Thank you. Other questions from the committee?
Good morning. I have a couple questions. So the amendment says that you're taking out the clause of being a disaster.
Right. It's just for MHCC housing across the board.
For drought and everything.
Right.
I mean, droughts and all that stuff. So I got a couple questions then. Maybe. So this was done by Governor Nixon.
Yes, 2010.
And this is called the Missouri Housing Development Commission.
Right.
Correct. And so I'm curious why we're putting this in law when the current governor, who the Missouri Housing Commission is made up of Eric Brighton's governor, Mike Parsons, lieutenant governor, Eric Schmidt, state treasurer, Josh Hawley, AG, Jeff Fay is the chair, Troy Nash is the vice chair, Greg Roberts is the treasurer, and William Miller is the commissioner. So right now, and save the taxpayers a lot of money.
Well, I would disagree that it's a lot of money to put a bill through, but I would also point out that it did happen, and it could easily happen again. I'm not looking at a one particular administration fix. This needs to not be done again in the future, regardless of who the governor is or what party's in control of basically the commission and the members of the commission. This is something that affects all Missouri citizens, and I think is definitely right being in the law to ensure that we don't have this type of a come out again.
Well, I'm just curious why we're, like I said, wasting taxpayers' time on this bill when it can be just done right now. And I'm just curious about that. Also, there has never been anything proven that when you take away prevailing wage, that the prices go down.
I will totally disagree.
A study that says that the prices actually go up.
I have a study out of California that discussed that in the California study, there were 3,000 some odd less housing units built when they did a prevailing wage input.
And I have a couple in Kansas that say the opposite.
Well, and obviously we know figures can disagree, but I have my own personal experience with Joplin. It was just an increase in prevailing wage from a lower rate to a higher rate. And I saw it, and I wrote the letters. I saw the units go down. I saw the quality go down. That's my own personal experience. I can testify to in having to write those letters and getting the responses back from my.
And I get some of those people there, I think, did not bid according to the law. I believe that was correct.
No, they bid according to what they were given by MHDC, but they had referenced a much lower wage, an old prevailing wage rate. It was not the new prevailing wage rate that was currently in effect in August of 2011. So they had to give them 30 days to refile. The commission was one that made the mistake. And in seeing that higher labor rate, again, a few projects didn't get filed. All the others scaled down, either quantity, quality, or both. And I was not happy to see either of those changes occur because of that. Because that meant I got less housing in my district in a disaster zone and less quality for the people that we're going to manage to get into the fewer units.
Okay, thank you.
Thank you.
Further questions from the committee? We will go for and against as we have in committees past, and so we just alternate between the two. So whoever would like to come up first, please. No one for or against? Anyone here for informational purposes?
Quick.
Representative Muscova said perhaps we should make it consent.
I don't know that you're, I would love that, but I don't think everybody would agree with that one.
Thank you, Representative. We appreciate your time. We will now move to Representative Wiemann's House Bill 238. Whenever you're ready, Representative.
Good morning.
Madam Chairman, Members of the committee, for the record, my name is John Wiemann, State Representative for District 103, St. Charles County. Today, I'm presenting House Bill 238 titled Public Labor Organizations. I also have a House Committee substitute, which I believe has been distributed pertaining to this bill. This bill relates only to public sector or government labor organizations. The purpose of this bill is to address the transparency and accountability of all public labor organizations on behalf of their members and, most importantly, the taxpayers. It is important to note that the House Bill 238 does not prohibit public employees from organizing or negotiating collective bargaining agreements. House Bill 238 addresses four main concerns. First one being Missouri public employees should have a say in deciding who best represents their interest. Fewer than 3% of the current government union workers have ever voted to choose their representation and whether to continue being affiliated with that specific labor organization. The current process of terminating representation or decertification is inadequate because it places the burden on the members to initiate that action and thus creating potential retaliation against those members requesting a decertification election. House Bill 238 removes the fear of members from retaliation by requiring labor organizations to automatically conduct recertification elections every 2 years. That's the difference between House Committee substitute has the biannual versus the annual. The cost to administer the recertification election in most cases is not difficult. It utilizes or can utilize electronic methods at a very minimal cost. Bottom line, if public labor organizations are representing their members' interests well, then they have nothing to be concerned about easily winning their recertification. Missouri taxpayers should have the same right to access public labor organizations' contract negotiations as they do with other government-related hearings and meetings. Currently, Missourians have little oversight of how their tax dollars are spent on government union labor agreements. The bill makes government union labor agreements public and documents presented by a public body during a meeting concerning a labor agreement or that a public body receives from an employee association shall be considered a public record. Third, Missouri public employees are entitled to know how their government union spends their dues. Currently, private sector unions already file financial disclosures with the Department of Labor for union members and the public to review. Unfortunately, public sector or government unions are not held to the same transparency standards. This bill will require annual financial reporting by government unions to include financial assets and liabilities, itemized expenditures, union officer salaries and benefits, lobbying expenditures, and political contributions. No individual, and this is important, no individual union member data is included in this requirement. Fourth, and finally, Missouri government and taxpayers should not be bound indefinitely to unsustainable agreements with public sector unions. Currently, many public sector labor agreements contain an evergreen clause that can bind parties to agreements many years beyond the original term. Basically, public sector unions can keep favorable terms in effect by not agreeing to new contracts even when the government cannot afford the existing terms. This bill would prohibit any government union contract from exceeding 2 years in length. As I mentioned, the House Committee substitute differs from the original file bill in a few respects versus the annual certification has now been switched to biannual, and also requires the reporting of any agency fees of any non-members and stipulates that no term or provision of extension of a labor agreement shall exceed 2 years. In summary, House Committee Substitute 238 is a pro-worker, pro-transparency bill. And Madam Chairman, I'll be happy to entertain any questions at this time.
Do you have questions from the committee?
I've got, Madam Chairman, I have one.
Proceed.
I have a lot of questions, but I just, now they changed it to biannual, so some of them might not be relevant, but we'll see. Good morning.
Good morning.
I guess we can just go through the bill line by line and I'll have questions for you.
Sure.
So on page 2, on section 1.105.533.
Are you looking at the House Committee substitute, or are you looking at the?
I don't have the House Committee substitute.
Okay.
I don't think any of us have the House Committee substitute. this is the annual one.
This is the action. We did not distribute the substitute since we weren't going to
Okay.
vote today. I'm
That's
so
fine.
sorry.
I'll just toggle between the two. Go ahead. On page 2.
Yes, page 2, 105.533. Says every labor organization shall adopt a constitution and bylaws and shall file a copy thereof with the department. So what other private organization has to do this? Any other organization would have to do this with it because of dealing with the state. Do you know of any other organizations?
Well, I know a lot of non-for-profit organizations, and I know that to file, bylaws and those types of documents. So
wouldn't this be for the members themselves? What would this have to do with anybody else? The members of the union, wouldn't this, as far as the Constitution and bylaws, shouldn't it be for the members?
yeah, that's what it's for.
That's
It's for their protection, so that they know what their organizations they are members of must follow as far as their guidelines and bylaws. It's for the protection of the members.
Okay. And then on line 9 on the same page, it says work permits. What does this mean? What are work permits?
Which one you're referring to?
Line 9 on the same page, just below it. Says work permits. It says the initiation fee or fees required for a new or transfer member and fees for work permits required by the recorded labor organization. What's a work permit?
I have no idea what that would be, whatever that's described as by their organization, if they have some type of work permit, but it's just simply requesting that they file disclosure of any initiation fees or any other
Should it say
fees that were related to being able to allow to work for that union.
Okay, initiation fees or work permits. You don't know what those are?
No, I've just, work permits, I guess, is something that you guys in the union may have required in order to be able to do a job for that particular union.
Okay. And then I have on page 3, line 35. And if you read that section there, it's every labor organization shall file annually with the Department of Financial Report signed by its president and treasurer or corresponding principal officers containing the following information in such detail as may be necessary to accurately disclose its financial condition and operation for its preceding fiscal year. So is that going to be biannually now, or is that going to be every year, or just, I don't have the.
No, the substitute, I think, left that as annual. The only thing that's biannual is the certification election. So that would be done annually.
Are you aware of any other private organization that has contracts with the state that undergoes this type of record keeping for the public to see?
A private organization?
Yeah, and that's what a union is, a private organization.
Yeah, they have to do it right now. They have LM filings that are required every year.
For the public to see?
I don't know about, it is private, or it's publicly disclosed. The private labor organizations that file their LM filings
No, I'm not
every
talking about
year.
private, I'm talking about organizations that do, private organizations which have contracts with the state that have to do this.
Private organizations
Yeah.
or private unions?
Well, private organization, any private organization which has contracts with the state that undergoes this type of record keeping for public to see. Do you know?
I'm not aware of any other private organizations that have to do that.
Okay, so this would be something that would just be imposed on a private union for employees, for members, but not other,
Public unions,
but not
yes.
other organizations.
I'm not aware of any other private organization that has to file their financial disclosures. They may have to, there may be situations where they may have to disclose that in order to have a contract, they may to make sure there's no conflict of interest. But
you know of no.
I'm not aware of it.
Page 5, towards the bottom. It's section 105.540, and line 4, it says, the department may publish any information and data obtained under such sections. The department may use this information and data for statistical and research purposes and compile, publish such studies, analysis, reports and surveys based thereon as it may deem appropriate. So what could possibly be this information be legitimately used for?
I mean, a lot of government agencies and departments compile data for us as legislators to be able to analyze what's going on within our government as far as how things are running or not running well. And I would assume that's what that's referring to, is allowing them the ability to be able to compile data, to be able to respond back to us when we have questions about whether a particular law or statute is working the way it's intended to work.
So you don't know, you assume you don't know exactly what this information could be used for, I guess, legitimately used for?
I would assume it's to be used for the public good, to provide information to us to be able to analyze whether whatever we're requesting them to do is in fact working the way it's supposed to provide us data. I mean, government agencies collect data all the time, all the different departments. I mean, the Bureau of Labor Statistics, there's a lot of different departments that collect data. General purpose for us to look at was a lot of times when we get research from government, that's where they're gathering that data on a cumulative basis to be able to come up with some research to show us or demonstrate to us that something is working or not working.
And then I think I moved over to page 7. 105.560. So currently, right now in the Constitution, Missouri's Constitution, members have the right to bargain with a union of their own choosing. Article 1, Section 29, I believe. So on 105.570, supervisory employees shall not be included within the same bargaining unit as employees they supervise. So what about the units that already have this in there? Would they be changed?
Well, yeah, I mean, if this is the way, I mean, they're currently doing that, which I would find it surprising, but if they are, then the supervisory employees would have to be in that bargaining unit, because it's kind of like the fox guard in the hen house. I mean, if you have supervisory employees that are in negotiations with the public body on a collective bargaining agreement, it seems like it's a conflict of interest, don't you agree?
Well, I don't know, we have foremen and they're considered supervisory in our union, so I don't know if that would be conflict of interest or not.
Well, that may be splitting hairs on what is determined as a supervisory position or not.
Well, it's unclear.
Supervisory within the company or supervisory within the union?
Well, supervisory, like I can say, in my case, I would be over employees on the job site.
So if you're a union foreman, are you also a supervisor within the corporation or within, I mean, that would be, I guess, how I would look at it is.
Yeah, we don't spell that out, so I'm not sure
Maybe that's something we need to clarify in more detail. Point well taken, but I would say that if it's foreman and you're supervisory within the union, but you're not necessarily supervisory under that public body, that would be my distinction between that.
So on the next line, it says the same labor organization shall not represent both non-supervisory and supervisory employees. Are you talking about their international union, district council, local union?
It doesn't specify that into that degree of.
That's something else that we could get cleared up a little bit.
Sure, certainly.
Sure. Then, excuse me. $105.575, and then it's line 3. You have it down here, it says bargaining unit. So there's no way to handle a dispute whether there's a disagreement about what the bargaining unit is. Does it still go through the Board of Mediation to find out which one is the bargaining unit?
Repeat your question for me, please.
In the bargaining unit, it says there's no way to handle the dispute if there is a disagreement about which one is the bargaining unit. But does it go through the Board of Mediation or?
Well, that's what it currently does right now, and I don't see in the law where it's, or in this particular bill where it says it doesn't. So I would, if the law right now says that the Board of Mediation is the one that does that, then they would continue to do that. It doesn't specifically remove them from that responsibility.
And then we have here is, says indicating that they wish to select their labor organization in question as their exclusive bargaining representative.
Oh, what line are you?
That's the line right below, sorry. Oh, there. So it's been said many times around here, and some members in this committee, that the union chooses who to represent or not. This requires the union to represent everyone.
Okay, so any labor organization wishing to represent employees shall present to the board cards containing the signature of at least 30% of the employees. That's currently already what's in place. And it says indicating that they wish to select the labor organization in question as their exclusive bargaining for the purpose of collective bargaining. That's all currently in place right now.
The exclusive bargaining representative for the purpose of collective bargaining. So right past bargaining unit, that's the part I was looking at. When you say exclusive bargaining representative, around here I've heard many of the right to work was that the union chooses who to represent and not represent, but now you're saying it's exclusive bargaining representative. Is that correct?
That's what it says there.
Then I have on page 8, line 23 through the end of 27. It says, however, no employee, no representative of a labor organization shall attempt to threaten, intimidate, coerce, or otherwise restrain any eligible voter in the free exercise of his or her individual choice to support or oppose this selection of the labor organization in question as the exclusive bargaining representative, again, exclusive bargaining representative of the employees in the bargaining unit. This does not mention the public body and their part in intimidation and things of that nature. Are we going to add that in, or is it just strictly for?
Well, I think it's in reference to,
are they allowed to intimidate, coerce, et cetera, without repercussion?
I don't know this for certain, but I'm not an attorney, so I don't know what the current statute is regarding what the other party can do. But if my memory serves me correctly, I've read somewhere where they're not allowed to do that either. But that's not covered in this particular bill.
And shouldn't this address that? Because this is
related to
a public body and
public unions,
right? And public body and contract negotiations and collective bargaining. Those are all in this.
I mean,
right?
If that makes you feel better, I could add it. I think it's just redundant language, but we could certainly consider that if that's something that you have an opposition or would help you feel more comfortable with that portion of it. I think it's already in current statute right now that they're not allowed to do that either.
And Representative, if I may, I want to be sure we get to all the witnesses. So do we have other members that have questions for the bill sponsor?
Inquire.
Proceed.
Thank you. Thank you, Representative. If I could direct your attention back to page 2 of the original bill. I believe it was discussions concerning section 105.533 concerning labor organizations shall adopt constitution and bylaws. There was questions regarding the necessity of that. Don't companies already file bylaws that have contracts with the state? This kind of tax, we're giving companies tax dollars, they got to file their bylaws, right?
I believe so.
And corporations as well.
Yeah. With the Secretary of State's office.
Why did you amend the bill to require filing every 2 years instead of annually, like Wisconsin?
On the certification,
Yes.
that was a compromise with various parties, interest groups that felt it was less onerous to do it every year. To do it biannually versus every year.
Wisconsin does it annually though,
That
right?
is correct, they do it annually. We had, the original bill was annual, and then it was, the Senate version of this bill was amended with substitute to make it biannual.
Concerning the gathering of 30% bargaining unit member signatures, how many unions and public unions have actually been decertified in the state of Missouri? Are you aware? I couldn't find any.
I think my notes, don't hold me to this, real quick. I want to say it was around 40, but I could be wrong. Don't hold me to that. Let me look real quick.
Well, that's okay.
Yeah, I can't find the number, but it's not a huge amount of,
Because it seems rather onerous burden to have to collect all that and do all that. It seems almost impossible, but I'm glad some have actually been able to perform that. So essentially, our private unions have to file all of this documentation, and they live on private dollars, but our public unions don't, and this bill would correct that, correct?
correct,
And the public unions live on taxpayer dollars.
correct.
Thank you.
Representative Scott?
Take one.
Representative.
Representative, on page 3, line 35, section 2, where it says every labor organization shall file an annual report signed by the president, treasurer, corresponding principal officer containing the following information in such detail may be necessary, accurately disclose financial condition and operations. Did you know that this actually is done by private organizations with the federal government? Just to address that issue, they file their 5500s. And we know through a bill that I filed, House Bill 80, that they don't accurately portray the picture. They do with the federal government, but not here at a state and local level. So they do actually file privately. Did you know that?
I do now.
Okay, thank you.
Do we have other questions from the committee? Okay, let's, you can call your first witness and then we'll
Sure.
go back and forth as well,
All right.
for and against.
I'd like to ask for Vincent Ferrucci from the Mackinac Center for Public Policy.
Madam Chairman, members of the committee, thank you for giving me the opportunity to testify. My name is Vincent Ferruccio, and I'm Director of Labor Policy from the Mackinac Center. I'm here to testify on the House Bill 238, which does three things: democracy, transparency, and fairness. And in short, in response to some of the previous questions, much, not all, but much of what it does is simply codify what's already in federal statute and federal regs and bring that to Missouri. I'm going to address a couple of things that may be new, and then I'd be happy to go back and talk about some of the federal laws and the federal regs that this bill is simply mirroring. The first is democracy. This bill protects the secret ballot. It says that you can't go out and organize a union and say you're going to represent people without having a secret ballot vote. Just like many of you, all of you, were voted behind the curtain, secret ballot. We want the same right for workers and for union employees. Codifies the election process. So right now, Missouri is operating essentially under a judicial interpretation of collective bargaining. This is bringing legislation and a legislative intent to say that elections, collective bargaining, we see what is standard across the country, and we're going to codify it here in Missouri. It also brings recertification every 2 years with the new bill language. It's bringing democracy, just like we vote for state legislature, just like we vote for Congress. Every 2 years, workers should be able to vote for which union represents them at the workplace. The cost that we've seen per vote And Wisconsin is the example here, is about $1.50. So we can give workers democracy for less than the price of a cup of coffee. Transparency, and this is where this bill is mirroring much of what the private sector does. Private sector unions, they file what are known as LM filings. And there's 3 different types. There's the LM2, LM3, LM4. I won't get into too many details on it, but essentially it says that union disbursements and receipts have to be filed with the Department of Labor in Washington, D.C. This is for private sector unions. The Department of Labor then posts them online. There's a website you can all go to. It's called unionreports.gov. And you can see these filings in detail. LM2 is probably the biggest filing. And essentially what the LM2 does, it says that all officer salaries, all receipts, all disbursements have to be accounted for. Anything above $5,000 has to be accounted for per line item. Any vendor for a disbursement or any receipts that's aggregate of $5,000 but below, that has to be accounted for. And then there's a sundry other category. That's for the LM2. Private sector unions are already doing this. What this bill is doing is simply mirroring what the private sector brothers and sisters of the public unions here in Missouri are already doing. Also says that Constitution and bylaws have to be posted online, same as we see in a lot of the private sector unions. It also brings fairness to the taxpayers of Missouri. It says that you can't have clauses in a contract that exist in perpetuity. There should be a time limit. It also says that these public employees getting paid with taxpayer dollars cannot do union work while they're on the clock. It says they can take time off, or they can take unpaid leave, or the union can reimburse them for that leave. That's fine. But if a public employee is doing union work, they shouldn't be paid with taxpayer dollars. Questions such as supervisory employees, and I believe that is mirrored very closely to what federal law and federal regulations say. The main issue there is this is actually something that, if you go back decades, that unions requested. Because what they didn't want is management taking over the union. So they said that no, supervisory employees have to be separate. Because you don't want a bunch of managers with the workers, managers taking over the union and voting with the employer and what's best for the employer. So it was to ensure union democracy and that the workers are protected. That's why I believe that language was in there, which is mirroring much of what happens for private sector unions at the federal level. And I do believe that applies to local unions. So you can still have both supervisory employee unions and non-supervisory employee unions in the AFL-CIO, for instance. You don't have to have them completely separate under the umbrella union. I'd like to open it up to questions, and I know there were a lot more directed at the representative. As far as the specifics of the bill and Missouri law, I will do my best. I'd be happy to address anything that deals with federal law and with the overarching comments. So thank you very much for your time, and I look forward to your
Questions for the witness?
May I inquire? Proceed. Morning.
Good morning.
I'm curious, where are you from, Mackinac? Is that from, are you from Michigan?
I'm from Michigan, yes. And I also worked in the George W. Bush Department of Labor, so I do have some familiarity with the LM2 file. Now I'm from Michigan. I was from DC then, but I do have some a fair degree of familiarity with federal labor law. That much of this bill is mirroring.
So one of the things you mentioned, you said that employees cannot do union business on paid time.
Correct.
So if they have vacation time, they can't do union business if they take a vacation day. That is their private time that they've worked for. They can't take a vacation day to do union business.
Oh no, they can do union business if they take a vacation day. I believe that is. I believe that's the language, at least in the amended bill that I see.
It says unpaid. It says you can't have paid leave. And it would be paid leave, right? you said you can take off unpaid and do whatever, but vacation day was you'd be getting paid.
In the bill, but at the end of the day, they should not be vacation or no vacation. What we've seen in Missouri and in many states is that they don't have to take vacation time. They simply are on the clock, and in the contract it says you can be on the clock and be paid your salary, not take vacation time, not take unpaid leave, but still do union work and not be working for the taxpayers at the same time.
Okay, so if you go to back, this question I was going to ask for the representative, but I'll ask since you're here and you know more about it, sounds right? Page 8. Line 48. It says any labor organization receiving more than 50% of the votes of all eligible voters shall be designated and recognized by the public body as exclusive bargaining representative for all employees in the bargaining unit. And again, we got that word, exclusive bargaining representative. My question is, if there's 100 people, excuse me, let's say 100 firefighters, 50 firefighters vote to join the union, recognize the union. Are you with me so far? Mm-hmm. And the other 50 don't vote at all. What happens?
Well, I believe under current law, if
This law.
if in this law,
Yeah.
you're not having a majority of the unit vote for that union, so that union would not be certified. Just why that union wants to be the exclusive representative for all employees, they should have a majority of the unit.
But the other employees don't even participate, correct? Excuse me, Michael. The other employees do not participate, correct? They're not members of the union. You have the right not to join the union, whatever.
Actually, I refer you to Representative Helms, HB 637, that if that bill passes, there's a concept called workers' choice that says that employees would be able to affirmatively opt out of union representation. That may change things. Under this bill, yes, the union would have to get a majority of the assent of a majority of the unit in order to be considered the exclusive representative.
So the actual members that say the 50 that want to be a part of the union, and they're going to be the ones paying the dues and putting the work in, the others are not doing anything. That decides who gets to bargain for those 50, is what you're saying. So essentially, you probably would very rarely ever have a union be formed.
Well, if there's a need at the workplace and that union gets a majority of the unit, the union wants to represent all employees, so therefore they should have a majority of all employees assent to represent them. Let me give you an example that we saw in Michigan. The SEIU wanted to represent home healthcare workers. I don't know if you're familiar with this here. They sent home a mailer, and they were able to do this via mail-in ballot. The mailer looked like junk mail. You had people like Robert and Patricia Haynes of Macomb Township in Michigan that were taking care of their 2 adult disabled children, and they were getting Medicaid money for that. They get something in the mail saying, "Do you want to join a union?" They thought it was junk mail. They crumpled it up, they threw it away. Well, the SEIU got returned about 20% of what was going to be the unit. Now, a majority of that 20% voted for the SEIU. Well, 80% did not vote, and therefore Robert and Patricia Haynes, taking care of their adult disabled children, getting Medicaid money for that, were now forced into a union. In order to represent employees, the union should have a majority of all employees in that unit. That's only fair.
Thank you. Do we have other questions for this witness?
Inquiry.
Proceed.
Can you go back on that statement and repeat that, please?
If a union wants to represent all employees in the unit, that they should have a majority of all employees.
And prior to that one, you were talking about?
Robert and Patricia Haynes of Macomb Township in Michigan.
But the union did send out information to the entire membership, and only 20% participated in that. You just stated that, right?
Correct.
And you're a statistic guy, right?
Actually, I went to law school because there was no math on the LSAT, but we can come back to that. I do know some statistics, yes.
Good. And so you know, in most organizations, only 20% usually participate anyway. Am I correct?
Depending on the organization.
Most. So we can agree on that?
I think it's depending on the organization. You know, there's some organizations where, you know, if you are believe in gun rights, you know, believe that everyone that wants to join the NRA does pay the NRA, but the NRA does represent everyone that believes in gun rights.
Still usually about 20%.
I don't know the answer to that.
Thank you. You really don't. That's the point I'm trying to make right now. And going back to the statistics that you just gave there, you know, in most organizations, when you send it out to, you do a good faith effort. So you send it out to the entire membership, usually 20% participates, and that's general rule when you look at statistics. So that caught my attention when you said there. So that's the only point I want to make right there, is that they made a good faith effort. And usually what comes back is what comes back. Thank you.
But not all organizations can say, we speak for you. And that's one of the privileges that unions have. And that's why they should be held to that higher standard.
But usually it's only 20%. So thank you.
Thank you.
Ask Representative for any question.
Proceed.
Before I get into this, is it something that you're gonna boomerang with me?
I don't think so, but I using his example, why should a parent taking care of their children have to join a union? And this happened in Missouri 3 years ago with a constituent of mine. And it was like, this doesn't make any sense. Why would you have to join a union to take care of your own relative to get the compensation, you know, that the government would provide?
Well, going back to that, that was not the point I was making, is that the information was sent to them and they did not respond.
Okay, but I mean, does it make any sense that a parent would have to join a union to get compensation to take care of their children?
Well, I understand what you're saying there, but they received the information, but they just didn't respond.
Okay, to inquire.
Thank you.
Proceed.
So I'm just asking a question of fairness on that issue. Do you have any idea of how many people fit in that class in Michigan as far as their family members taking care of their disabled children? Or do you have any clue of that?
Thankfully now in Michigan, the number is 0 because we did away with, there was both legislation and executive action to do away with the scheme.
Okay, thank you very much.
Other questions from the committee? Representative Paskey, proceed.
Earlier in one of our previous committee hearings, I talked with some union members that were required to vote on something, and they had a large number. And do you know if this case, they said a no response is a no vote. It was presented to them. If you don't respond, your vote goes down as a no. So the ones that were for it were outvoted heavily because, like he said, I think they said 25% actually voted yes. So, but the way they worded it, and voting no, based on no response. Has this ever happened? Do you know of any other cases this might have happened?
No, I'm not aware of any, but the good thing about this bill is, once again, you know, we're talking about collective bargaining coming to Missouri through judicial court decision. With this bill, we are now codifying what collective bargaining is in Missouri. We're being very explicit over how a union is elected, how a union stays the representative of employees. So when you talk about being tricked, that's why a bill like this is so important, because now we're putting language in the law saying this is what's permissible, this is the rubric of how collective bargaining works. And it's going to be answering those questions. So that's why I think putting this language in law is so very, very important, because right now there is a lot of confusion, and there is that opportunity for deception and for trickery, because there is so much confusion out there. Clarify a lot of that confusion. I don't know if I answered your question, but
No, that's what I was wondering, if this would eliminate that problem for these people. So, thank you.
Other questions for this witness? Thank you. Please be sure to leave a witness form.
thank you.
Someone against? Morning.
Good morning, Madam Chair. Happy Valentine's Day.
You too.
For the record, Jeff Rhoda, testifying on behalf of the St. Louis Police Officers Association. We are Lodge 68 of the Fraternal Order of Police. And I'll mention also that I was a state representative for 8 years. I mention that only because, for those of you that I did not have the pleasure of serving with, I want you to know how much I respect this institution, and I don't want you to mistake any of my testimony as being anything but respectful of this grand institution. I represent about 1,200 police officers in St. Louis City who put their lives on the line every day. And we consider this the most anti-police legislation going through the legislature this year. Not Representative Wieman's intention. He's a good man. Senator Onder as well. He and I have talked extensively about this bill. I understand that that is not bill, but it is the practical result of this legislation. Let me tell you why. Over the last 3 years, since the social upheaval in Ferguson and the incidences we've seen around the country that have followed, the only thing that has saved law enforcement officers has been their union, the Fraternal Order of Police. It hasn't been the politicians who say they love us. It hasn't been the politicians who say they hate us. It has been our unions. Campaign Zero, we consider a radical anti-police organization that was responsible for fomenting much of the violence against police in Ferguson and elsewhere, has as their number one goal, collective bargaining rights for police officers. You're aligning yourself with the most anti-police elements that emerged in Ferguson if you vote for this bill. Ms. Jane Duker is an attorney who represents the Fraternal Order of Police and the International Association of Firefighters. She's going to talk about some of the technical problems with this bill. But I want to talk about the practical and emotional issues with this bill. I'm wearing a bracelet today that says, "Stand with Stockley." Jason Stockley is a young man, served his country in the military, returned from that duty and served his community as a police officer in St. Louis. He was involved in the pursuit approximately 5 years ago. It ended with the person being chased, flourishing a gun at him, and forcing him to take the man's life. At that point, the circuit attorney in St. Louis looked at that case, said there's nothing here. But she handed off the U.S. Attorney's Office to look at it. The U.S. Attorney's Office looked at it, they said there's nothing here, no criminal violation. But they said, just in case, let's send it up to the Civil Rights Division of the Department of Justice. Civil Rights, Eric Holder's Department of Justice looked at this case and said, there's nothing here, nothing criminal here. Then comes Ferguson, and then comes a reopening of this case. And this young man who was the victim of a crime, was a victim of an attempted murder of a police officer, is now charged with murder in the first degree, premeditated murder. Who came to his rescue? Who posted his $1 million bond? Fraternal Order of Police did. Who's defending him in court? Who will spend hundreds of thousands of dollars in defense of this young man who's wrongly accused? The Fraternal Order of Police did. Who's putting food on this young man's plate while he struggles through this incredible, unfair journey that he's on? The Fraternal Order of Police is. This bill, the practical effect of it would be to make it impossible for us to continue as a union, to make it impossible for us to represent this young man and the heroes like him that find every day for the folks up here on this panel. And I'll point out that there would be no folks on this panel if you held yourselves to the same standard that you're holding public employee unions to right now. In this bill, it's required that over 51% of the people in the bargaining unit, not the people that turn out to vote, but the people in the bargaining unit, favor of recertifying the union every year. I appreciate that the substitute takes that to 2 years, but it's still an impossible standard to require 51% of the entire bargaining unit, because there's apathy in the electorate in a workplace, just as there is apathy in the electorate in our districts. I assume that most of you did not have 51% of your voters turn out for your election, and you wouldn't be here if you were held that standard. And I'd also mention that even if you had over 51%, you didn't have to, as unions do, have an option of no representation. Think of this anti-politician era. If it said on the ballot, Representative so-and-so, or no representation, how many people would vote for no representation? So you're holding unions to a standard that you and I in the past are not held to with the electorate. Also in this bill, 105.510 is not repealed. It remains in effect. 105.510, law enforcement, prohibits law enforcement, bars law enforcement from access to the State Board of Mediation. Yet this bill requires all of these reporting and makes the State Board of Mediation the only regulatory body that police unions can go to continue their certification, to challenge decertification, but we're barred from the access to the State Board of Mediation. So that's really a fatal flaw in the bill, as is the provision that requires that police officers and sergeants can't be in the same bargaining unit. We currently represent both police officers and sergeants. The state constitution, as has been pointed out, states that in Article 1, Section 29, as Representative Beck pointed out, that all employees in the state of Missouri shall have a right to representative of their own choosing. You're taking that right away. You're trumping the Constitution with a state statute, which I think in court for years and years. So, in closing, if you want to regulate state employees, this is the state legislature. If you want to regulate state employees, that's fine. You want to regulate employees that have access to State Board of Mediation, that's fine. Don't lump police officers in there who depend on their union to protect their livelihood, to make it safe for them to work, so you can be safe in your homes tonight. And I'm glad to take any questions, Madam Chair.
Thank you for that. Thoughtful.
Never been accused of thoughtfulness.
It was very interesting. I appreciate that. Do we know how many states have passed decertification? And that might be a question for the bill sponsor. You may know that.
I just know that we were involved in a decertification campaign. The sergeants had originally elected another union to represent them. They did not get the attention that they wanted, and they overwhelmingly voted to decertify and then to certify us as a representative. If this bill were to pass, they would be high and dry. They would be without representation and would be sort of twisting in the wind, and would have a terrific case for a constitutional violation in court.
To answer the question, part of my knowledge is Wisconsin is the only state that's actually passed this specific type of decertification bill. I know Iowa's entertaining it right now as well, but that's the only two states that I know of.
How long ago was that?
Wisconsin was in 2011, and Iowa's it's going on right now.
And has their officers been able to certify in Wisconsin?
What's going on, I'm not as familiar with Wisconsin, but what's going on in Iowa right now is you've got masses of police officers and firefighters turning out in front of the legislature. They're begging them to stand with public safety workers and to not cripple the people that make it possible for them to deliver the very important public good that public safety workers deliver.
Maybe I'm missing something, but I mean, I know that the union workers are very proud to be union workers and the police officers as well. And so are you saying that they wouldn't have the numbers to recertify?
I'm saying that you've established an impossible standard, and even if we could meet that standard, you require us to meet it with a state regulatory board that has no regulatory authority over us, that we are barred from accessing. You know, we currently have to go, police unions have to go employer by employer because the state board of mediation won't accept petitions for certification or decertification with regards to police officers or highway patrolmen or sheriff's deputies. We have to go employer by employer. They have to create out of whole cloth their own system for certifying and decertifying. Often they're flawed. Often we end up in court. It's an arduous process that just makes it more difficult on law enforcement than any other public employee union. We're really in a very special category because not only are we not state employees, we're local government employees, but we don't have access to state board of mediation. And in this bill, we're required to get relief, an agency we don't have access to.
Thank you for that. Do we have Representative Rowan?
Madam Chair, to inquire, please.
Proceed.
Thank you, Madam Chair. Number one, thank you for your service, and thank you for your incredibly articulate response today. I cannot say thank you enough. You bring up an excellent point. I'm thinking about an amendment for this bill, and I'd like to get your thoughts on it. One of the things I would like to put on it is, as a member of the legislature, if we were elected by less than 51%, that seat would remain open until enough people voted to do that.
If you held the legislature the same standard as they'll hold unions do, that's true, yes.
Because you make an excellent point. I was elected in a special election in 2015.
You know, about 20% of the voters turn out?
I wish I would have. I literally visited 90% of all the homes that voted in that election. There was less than 7.5%.
Wow.
Everyone who came to that polling booth that day, I personally met. And to hold us to a standard where we had to get 50%, we would not have any representation. And I can completely agree with you. To have this kind of a standard placed on any organization is completely beyond the realm of logic. And for police officers to have the responsibilities that you have and protect us, and I cannot say thank you enough for your service, but for that to happen, this is beyond my comprehension of reasonable legislation for this requirement to be happening. And I cannot say thank you enough for your testimony, because it just absolutely opened my eyes to what's happening. I cannot say thank you enough. And with that, Madam Chair, I'll close. But thank you.
If I can respond, Chair, real quick, Representative. If you carry that logic out to its full function, it's saying that not voting is voting no. That the people, that 92.5% of the people that stay at home by staying home. And that's what the function of this legislation would be.
Right. There was legislation introduced this week. There's an interesting idea. And the idea is if they have two candidates on the ballot, but they also have the voters have a third choice. And the third choice would be none of the above. And if none of the above were to win, you would not have an election. But if we use this logic, we're basically saying by not voting, you're opting out and you choose not to have representation. And I don't think that's how democracy works. And I don't think that's the standard we should have for this organization. And I think that should be the standard for the FOP. And so,
and current law requires that none of the above is always on the ballot in a union election. The voters in the union election can always choose no representation, none of the above.
Right.
And we're fully supportive of that. It's just, you know, put us on an even par where you're voting either for the union or for none of the above, that you're not voting for none of the above by not showing up.
Right. So thank you very much for your testimony. Thank you, Madam Chair.
Thank you. I would just argue that if the vote, since we are taxpayers and we are being represented, we're paying for representation. I think that if that were the initial rules, that if you don't vote, you're not going to be represented at all, then people would turn out. But this is saying that you get to represent yourself, I'm assuming, if you're not, if you decide that you don't want to be union. And so that's, I think, the flaw in the analysis.
Is there really a distinction between dues payer and taxpayer, Madam Chair? I mean, our members are all paying dues. I mean, it's similar to your constituents paying taxes.
Yes, because with right to work, you have a choice. Well, you guys are public employees, so you have a choice to pay the dues to be in it or not. Whereas taxpayers, we don't. Representative Viscovo,
Tim Clark.
proceed.
Representative, how are you?
Morning, how are you?
Rolling Hills of Jefferson County, like myself.
I once represented about 2/3 of your district. I hope you're taking good care of it.
I am taking great care of it, and you know for sure that more than 51% turned out in my election.
I will point out that not all that 51% voted for you, though.
That's true. That's accurately true, but I would say that 20%, 20 points more voted for me than my opponent.
I do recall that, yes.
So I love this building and the things we know and don't know about each other. Did you know that I used to live in St. Louis City?
I didn't know.
Did you know that I was on a jury trial in St. Louis City? I sat on that trial as a member, and we considered the future of a young gentleman that tried to murder a St. Louis City police officer. You know that?
I didn't know that. The right thing never came up before.
The great things we don't know about each other in this building. Did you know that I voted to a young individual to jail for the rest of his life for attempting to kill a St. Louis City police officer?
Thank you.
I guess that what aggravates me is the politics behind all of this. Saying that, you know, and not what you said here is against what I'm telling you, but the rhetoric I've seen on the internet and the FOP posts that come across my Facebook feed about how, since I'm a Republican, I'm anti-union. Would you say that I'm anti-union? I mean, anti-police officer, anti-law enforcement? I'm sorry.
I'll point out that my union endorsed Donald Trump for president. We endorsed Mike
Sure.
Carson for lieutenant governor and for treasurer.
My apologies when I said union. What I mean is anti-law enforcement. Would you consider me anti-law enforcement?
Vote on this bill in its current form, anti-law enforcement. But I don't think that's the intention of anybody that votes yes on this bill. That's why I'm here today, is to put a fine point on the functional effect of a bill that has a different intent than its actual outcome would be when it comes to law.
So when I take my highway patrolmen that represent Jefferson County, I take them out to dinner. I bet you didn't know that either, did you?
You never invited me, so how could I know?
Well, it's not like you and I sit around and have a beer every once in a while. I mean, what I'm saying to you is it's ridiculous to sit there and say that we're anti-law enforcement. We're not. Would you say that Representative Wiemann is anti-law enforcement?
No, not at all.
You just hesitated with me, though.
He's sitting closer to being representative.
But I guess what I'm getting at is who's voting to recertify these unions?
Not enough people.
But who would be under this bill? Who would be voting to recertify their unions?
The police officers I represent.
Right. So it's your own members that you need to turn out. Correct? Just like we try to turn people out in elections, that's what you're going to have to try and do. Is that too burdensome for you to go to your members and say, hey, and given the example that you gave of the officer from 5 years ago, he posted his $1 million bail, you need to do to turn around and let your own members know?
We got 1,100 members plus, and I'm lucky if I had 50 turn out at a meeting. It doesn't mean that all
I've got
1,100
35,000 constituents.
Right,
I mean,
right. And if you have a town hall, you don't have 35,000 people there.
But to show the importance of your union, you have to prove your own ability to maintain that membership and represent them. Don't you? Wouldn't that be?
Absence is not dissent, though, gentlemen. It's the fact that they don't show up at the meeting, the fact that they might not return their ballot doesn't represent dissent. It represents apathy, which is just part of human nature. And this bill capitalizes on that apathy to such an extent that it makes it impossible for a public employee union to survive. And we get this bad rap for, as unions, for representing the worst employees in the bargaining unit. Well, that's who you're catering to here. The worst employees, the same people that show up late for work and don't do a good job and don't have supervisors, the same people that probably are not going to return their ballots. So that's who you're advocating for here.
And you want to keep them as members.
Even
though they don't participate, they're your worst members, but you still want to keep them as members.
Not just my members, but members of the bargaining unit. I have to, under Davis-Bacon, under state law, I have to represent everybody in that bargaining unit, even if they're not a member of the union, even if they're not a dues payer, even if they're not a fair share payer. I've got to represent them all. And I do that with gusto, and I do it with zeal, and I don't distinguish when it comes to whether they're a dues payer or a member or a non-member. I protect everybody in that bargaining unit because that's my job, to protect the people, that protect the citizenry.
Wouldn't your job under this bill to turn out those members to recertify also?
And we would make our best effort to do that, but it is a burden and almost an impossible standard.
Thank you, Representative.
Thank you, Representative.
Thank you. Representative Orta, thank you for coming. I've seen you at many police functions around the city, and as you know, my father-in-law is a retired St. Louis City police officer.
I know that well, yes.
I guess I'm trying to get my head on public policy. The public policy reason to have an election has clearly been stated, and therefore it isn't necessary to have more than 50% of the people turn out and vote. And the necessary form of a government and a democracy just to simply have the vote you choose to show up. But I don't quite see the public policy reasoning to simply say that if you don't show up to vote, it's a good vote for a union. The union needs to have a compelling reason that can want its members to come out and vote and show why the union has value. So I just respectfully don't understand Representative Rowland's discussions concerning the analogy between a public vote and for a democracy and the role that the union serve, which I commend. And I would certainly say I would want the union to do a good job. And if the union is doing a good job, then more than 50% of the people would in fact turn out and vote. It's a compelling reason, and I just wanted to make that statement.
I just want me to make sure you understand that they don't now. It's very seldom that you have over 50% turnout to vote. And when you're on the ballot, you're on there against Joe Schmo who's running against you. And if it was just the same case with us, if it's us against, say, the Teamsters who represent police officers also want to represent our cops. If it's us against them and you got to pick between one of the two, that's fine. But when it's us against none of the above, and all the people that don't show up have their vote credited to none of the above, it creates an obstacle to democracy, really. I mean,
no, but what's none of the above? Maybe they just don't want representation. They don't need to have representation. That's not a government. You're a union. And respectfully, I mean, I definitely see the value of the union. I see the value of the union that my father-in-law has been a beneficiary of. But there's got to be a compelling reason to want to keep that union. You got to keep selling yourself. You got to keep showing the public, your employees, the value that you deliver. And that's why you need more than 50%. You just can't put people into joining a union because they don't vote.
Gentlemen, I got more scars on my knuckles than I do on my chin. I mean, everybody I represent knows how much I bleed for them.
I don't question how much you believe in it in your fight, and I commend you for that. But I guess the thing is, we all face with our constituents alone to try to deliver the message. And the compelling difference between a public policy argument for democracy and a union is apples and oranges.
Well, they're rotten apples to us, gentlemen.
Well, thank you for coming today.
Thank you.
Thank you. How many, let me see a show of hands, how many more we have wanting to testify today? Okay, so we're going to speed this up. Thank you.
I'll stop being so witty. I think the panel just wants to hear me be funny and sort of your dancing monkey chair, so I'll try to be less entertaining.
No, we appreciate your time, and it's good to see you again. So thank you, and we'll go to the next one.
Representative Miller just suggested that if 50% of the panel doesn't want to hear anything else from me, that's democracy in action.
Thank you so much for your testimony.
Thank
It's
you.
good to see you.
Thank you. You too.
4.
Thank you, Madam Chairman. My name is Greg Keller. I'm the president of the Missouri Century Foundation, which is a C4 based here in Missouri that supports free market solutions to move Missouri public policy forward. You all have a lot of people here to testify today, so I won't reiterate the reasons that Missouri Century supports this particular bill. I will just clear up, I think, however, one that's come up several times, which is that somehow getting 50% of people to vote constitutes what Representative Rorta called a quote-unquote impossible standard. That has proven absolutely, however, not to be the case in other states in which bills similar to HB 238 have been passed. I would point you specifically to the example of Wisconsin, which under Governor Scott Walker passed a bill nearly identical to HB 238. In the years subsequent to the 2011 passage of the bill in Wisconsin, upwards of 90% of all unions were recertified under that bill. I will repeat that. Upwards of 90% for every year on which we have data in the state of Wisconsin following the passage of that bill, upwards of 90% of every union was recertified. They did so under the same circumstances in which we did here in Missouri, which is requiring better than 50% of the vote. So the idea that somehow getting 50% plus one of your people to vote is simply has not been borne out. I will also point out, Representative Wiemann talked a little bit earlier about the cost of these recertification votes. It is true what the representative said, that it can cost as much as $1.50 per person per vote. I believe the representative said that it's, or maybe it was Vinnie Bernuccio said that you're bringing democracy to people for less than it costs for a cup of coffee. I will tell you that that $1.50 number is actually a lot higher than what it necessarily needs to be. There are universities like Harvard and like Yale that hold similar votes with their boards of directors and their members of their various committees. They do it electronically, they do it via computer, they do it by phone, and they do it with certified processes that cost as little as 9 cents each. So those are just be the 2 points I would want to mention, is the fact that it's actually a good bit cheaper than what we may have originally mentioned, and the idea that this sets some kind of impossible standard just doesn't that we've seen in other states.
Thank you for your testimony. That was what I was trying to figure out, is if we had any test case on this. So
we do.
That's good to know. Do you have questions for this witness? Seeing none, thank you so much. Against?
Good morning. Hi, I'm Jane Juker, and I am representing the Missouri Fraternal Order of Police and the Missouri State Council of Firefighters. And I won't reiterate a lot of what former Representative Rorta talked about, because he did actually steal a lot of what I was going to say, which is good. It's difficult, it is. One thing that needs to be remembered is that, you know, it's in our Constitution, the right to choose your representatives and to bargain. And that includes with it that you actually have to sit down and bargain. And at some point, regulations become so burdensome that you actually interfere with the constitutional right that's guaranteed and that the people voted on. And we believe this bill does go too far for that purpose. The recertification, even if it's stretched 2 years, is incredibly burdensome, and I won't go through, he eloquently talked about that process. The other issue is the payment. I mean, courts don't generally look favorable on taxing people to exercise their constitutional rights. I mean, this is a constitutional right for these members, and now they're being forced to pay for that. And taxing a constitutional right can cause tremendous legal problems. Also, I mean, there's due process issues that Representative Warder did talk about, which is, do they really have the ability to have the issue of certification under this language because they don't have access, the people I represent don't have access to the State Board of Mediation. There would be due process problems with not being able to advocate and be able to determine bargaining units. Also, the burden on local government. I mean, in Missouri's always been a local control state, and you're taking that away from local governmental bodies who all have unique concerns, especially when it comes to firefighting and public safety and police officers. And nowhere in Missouri law does the state govern with such detail how a local governmental body will expend its resources for something so fundamental, which is public safety. And also in Missouri law, the amount of information that is being requested and that will be in these reports far exceeds what any private party ever has to provide in order to contract with any governmental body, state or local. And that's problematic because then it begins to look like a punishment for exercising your constitutional rights. And the idea that forcing public governmental bodies, local governments, under the Hancock Amendment, forcing them to renegotiate every year, and I'm not sure if the substitute, you may be able to tell me.
It's the same.
It's the same, so it'll be an annual bargaining. Well, local governmental bodies have to take away and use resources in order to negotiate every year, and there may be a Hancock problem with that. And so, I mean, these are just some of the legal issues that I think come up, and I think local governmental bodies are frankly just better suited to determine what resources they need for their most fundamental function, which is keeping their citizens safe and healthy. Any questions, I'd be happy to entertain them.
To inquire. Thank you, Ms. Duker. It's a pleasure to see you not on the TV or radio.
Thank you.
Representative Porter brought up a component of the bill that is not in the bill, but nonetheless related to the section of statute 105.510. And you said that police and law enforcement are barred from participation in the State Board of Mediation.
Correct.
Can you please articulate why? Is there a public policy there? What's the foundation?
While there was judicial determinations that indicated they were allowed to collectively bargain, that is a legislative enactment that they don't have the benefit of. So you don't want to confuse the right to collectively bargain with the ability to access a statutorily created process. So they're not authorized. So the people listed in 510 are not authorized to go to the State Board of Mediation. It's a technical sort of, there's nothing in the Constitution that says you have to go to the State Board of Mediation. It's not constitutionally mandated. So that judicial case that actually allowed public unions to collectively bargain like their private counterparts, that doesn't apply to that process. So you just have a logistical problem.
Okay, well, what I did like was that this codifies the ability to collectively bargain for a public unit. But I understand, though, that where the State Board of Mediation comes in, I'd like to better understand why that might impugn the ability of a police organization not to participate in that if you're asking them to fall into the statute.
I mean, I think you would need different language to do that. It's a logistical problem, not a constitutional one.
And
But I do think that,
suggestions.
yeah, oh yeah, absolutely. And one other thing that I wanted to bring up, the LM2, which does require private unions to disclose a lot of information. This goes further than that. There's a lot of information requested in here that wouldn't be in LM2. So this would not be parity with the public unions and what they disclose federally now. I mean, I think it would have been easy to incorporate the same qualifications and the same information requirements, but that wasn't done. They were enumerated, and if you go through the LM2 and you compare it to the statute would require a lot more than what's in the LM2. So actually you would be putting my clients, the firefighters and the police officers, in a worse situation than would be the private unions now.
Absolutely.
Sure.
Thank you. Representative Miller,
No, go.
To inquire.
proceed.
Okay, I've got a question. You were talking about cost and how it puts it on kind of shaky legal ground. Does Wisconsin have a cost associated with theirs? Do we know?
I don't know, because, I mean, I think, you know, Mr. Keller testified to what he believed the cost of certification, but the actual bargaining. So every year having to rebargain contracts, and, you know, when you have longer contracts, not only do the union members benefit from that, but the local governmental body has certainty. And there's a certain amount of, you know, benefit that's given financially and otherwise to being able to have some certainty in budgeting and contracting that would be taken away from this. And I don't have an exact cost, but I'm certain there are public governmental.
Right. I was just
that have to
wondering
do
if
this.
Wisconsin had been challenged on the cost.
I don't know if they have a Hancock amendment. I'd have to look at that.
Well, and that's the other thing. I'm getting to that. I mean, that you challenge on the cost. Basically, you were saying that the U.S. Supreme Court has a little problem with associated with bargaining. That would have really nothing to do with Hancock. In my mind, it would be sort of just a cost to, as you said, exercise your constitutional rights.
Well, there's the cost that the union members would have to pay, and that's private money. I mean, that's their paycheck, and they elect to pay dues. And you don't have to pay dues if you're in a public union. So it really is private dollars that are going toward this. But from the governmental side, there is a cost associated with taking employees and forcing them to renegotiate.
Right. I was just curious about the cost and the challenge, and if that had already been done. Okay.
But no, we haven't done a survey of all the local governmental bodies that would be impacted by this bill and how much money they would have to spend in resources in order to renegotiate their contracts every year with their public safety workers.
And I agree, it does seem cumbersome. I mean, I get kind of cheesed when I see some of the reporting, because I don't like doing half the reporting I have to do. So the Hancock amendment, that was kind of interesting. It seemed kind of like a small amount. It seems like a lot of small amounts fall underneath on Hancock, especially since I think Hancock has outstretched us by a long ways because of 2008. So, I mean, is Hancock really a concern on this?
Well, it's an unfunded mandate, and that's the difficulty. It's not ever, are we going to hit the other part of Hancock, which is when you take refunds and you ever get, I don't know, we'll never see revenue good enough to get us under Hancock again. But this is the unfunded mandate part, and you have a lot of public governmental bodies.
I think, is that even under Hancock? That's just sort of a general constitutional deals. You don't want to.
My understanding is Hancock prevents unfunded mandates to local government bodies. If you're going to mandate something, you have to fund it.
Okay, I don't remember that part, but I'm not a lawyer. I've just been in the House for 4 years. Oh, I'm a land surveyor. I don't know if that counts or not. I can't remember how that goes. Anyway, okay, I think that covers my question. Thank you.
Thank you. Representative Rowan?
No, I'm good. Thank you.
You're good? Okay. Proceed.
Morning.
Hi.
A couple questions. One, observation. I've been on the school board for 7 years, and I've been a part of the collective bargaining. And one of the things we did a few years ago is we negotiated, right when the economy downturn, we negotiated a 4-year deal, which gave us we knew exactly what our costs were going to be for the next 4 years. So if you have a plan as a district, fire, police, so you know where you're at, and it really was helpful. But this would eliminate that, right? This would only
Correct.
be a 2-year.
All financial terms would have to be renegotiated every year, and they have to be done by July. So yeah, I mean, there's a difficulty with getting that done every year.
That'd be a burden on local governments, and because I know how long it takes and to actually negotiate. And then also, I think this whole bill basically tries to circumvent the Constitution and take away the rights, in my opinion.
I think the cumulative effect of all the burdens would impinge on the right that is guaranteed by the Constitution. That's a problem. I mean, you take one provision, maybe not, but certainly the totality of the burdens imposed by this proposed legislation, I think, would interfere with the constitutional right.
Now, I have another concern. I don't know if you have the bill in front of you, but on page 10, line 17, down to the end of the page. I don't want to read it again, but
Oh, the negotiating and how all of that's done in public, and that's very challenging. I mean, anyone who's negotiating, real estate contracts, all kinds of contracts.
Let me read it real quick, though.
Sure.
It says, before any proposed agreement or memorandum of understanding is presented to the public body, a labor organization, as a condition of its presentation, shall establish that it has been ratified by a majority of its members. The public body may approve the entire agreement or any part thereof. If it rejects any portion of the agreement, the public body may return any rejected portion of the agreement to the parties for further bargaining, or the public body may adopt a replacement provision of its own design, or a public body may state that no provision covering the topic in question shall be adopted. Any tentative agreement reached between party representatives shall not be binding on the public body or labor organization. So that basically gets rid of negotiation and collective bargaining.
It makes it very good.
Yes, you can, and then later on, I think it states it too, that basically gets rid of the whole negotiating process.
Yeah.
So, I think it does go back to taking back the article, Article 1, Section 29, the constitutional rights to be represented. This bill, I think, is just a very bad bill.
Thank you. Thank you so much for your testimony. Have a good day. Move forward to the next witness, please.
Good morning. My name is Brian Hay. I'm an attorney with McMahon Berger. Our firm has represented management and labor employment for over 60 years. I personally have represented municipalities in collective bargaining. And I'm here to testify in support of the bill. First, a little background just for your benefit. FDR originally was against public bargaining. He didn't think that there should be any public bargaining with government employees. The constitutional amendment that Missouri passed was in 1945 that said we'll collectively bargain with all employees. Well, when it was passed, there's no point in making a distinction between public and private employees because the law of the land was you could only publicly bargain or you could only bargain with private employees. It wasn't until 1962 that John F. Kennedy passed a law that says federal employees can publicly bargain. And then just recently, the Missouri Supreme Court interpreted the Missouri Constitution that says all employees, so that includes public employees, which is fine. That's where we're at now. And I think this bill aims to deal with a framework of how we go about collectively bargaining with public employees. It's not to eliminate it, it's to establish a framework. The first section regarding the financial disclosures is modeled after federal law. I don't have it word by word, but I know after reading the federal law, it's modeled after federal law. And as far as I'm concerned, I've never heard any complaints from private unions with respect to the reporting procedures. The second part of the bill has to do with a framework. And it seems to me that framework is modeled after a decision by the Western District of Missouri, City of Grandview. And what the City of Grandview did was they had some police officers who wanted to publicly bargain. 5, as I stated before in the background, doesn't address how you publicly bargain with police or teachers. So they had to establish their own framework. And the framework that you're looking at in this bill is almost identical to the framework that the Missouri Court of Appeals found to be valid. So keep that in mind when you're reviewing this bill, whether or not it's constitutional or legal. One more comment about supervisory units. I know there's been some testimony that there's a concern that what happens to sergeants in these units. To the best of my knowledge, the contracts in place are going to be valid until they expire. After they expire, the contract's going to redefine what the bargaining unit details. And it may not entail a supervisory employee. And there's an important reason for that. When you're at a grievance procedure, an arbitration for a termination of an employee, one of the first witnesses that you bring in for the termination of an employee is their supervisor. If the supervisor and employee are in the same union, there's going to be an obvious conflict of interest. That supervisor is going to be very reluctant to give testimony in front of an arbitrator that's going to lead to this employee's termination. Or the union may put pressure on the supervisor not to give full, complete testimony. So we want to eliminate that conflict of interest, and that's why we believe that different bargaining units for supervisor employees makes sense.
Thank you very much for your knowledge on this subject. I know we've kind of had a lot of questions going through. And do we have questions from the committee for this witness? Proceed.
Just to make a comment on this, I know this does happen because as far as the, when you have a grievance, I had a member in my district that came to me with a problem within one of the law enforcement agencies, and he had no place to turn. So I want to commend you for bringing that point up, because I couldn't direct him anywhere. He had no place to go because of that particular reason. So I hope that will clarify that for some of these officers. Thank you.
Thank you so much. Please be sure to leave a witness form. Against?
Good morning, Chairman, honorable representative members of the Economic Development Committee. The clerk's record, Clark Brown from the Missouri State Council of Service Employees International Union, SEIU. Just a couple of comments. There's been an awful lot of information that has been given here. I wanted to come back to principle fundamentally, and I think we heard in some testimony. I think sponsors of the legislation may look at this as offering some type of choice to employees, but I want to remind you, this choice for the employees with the accountability that you guys as lawmakers are considering comes at a cost to the employees. I don't see a fiscal note for this legislation. The companion version in the Senate, which also has been modified as far as the terms of the election cycles, had an $880,000 fiscal note to the state, but also the unions and the fees involved look to be around $160,000 every year that comes out of the union members' dues that conduct these elections. I come back to say the real point of this, we always want to be stewards or watchdogs over our citizens, whether they're union workers or non. I think you're looking at making a decision about something that will actually cost them, when in fact we see this every year. They're not here testifying saying they need this legislation. And in fact, when you dig deep into the process, there is already a decertification process there for workers. Testified last year, and it was closer than I get further and further away from it. I had a decertification 3 years ago, and it was a public union. And I think that happens if you get out of touch with those workers. If you don't deliver service, they're going to petition with just a third of the body, and they're going to have an election conducted, and they're going to run their union out if they're not working for them. So want to make sure that also emphasize, I know it was spoken, the details inside this bill are way deep overreach. I have no problem about reporting, but this thing's got about personal financial disclosure, are all kinds of things that I think are way out of bounds or over the boundaries and beyond what we would think is proper expectations for reporting. Closing, don't forget, this is a question too about, do the public employers want this? When I called last year on this legislation, there were 611 public entities certified at the state board, according to Jane over there. That is not including the police and fire units or some of the teacher units that haven't had elections conducted by the state board. So we're potentially talking about what the other numbers, but it's 611 plus that you're going to say now to these political subdivision entities, you're going to have elections every other year. And again, I don't know that this is something you see them here testifying saying they want that to happen. Thank you.
Thank you. Do we have questions for this one? Seeing none, thank you so much. 4.
Thank you, Madam Chair and representatives. My name is Jane Cunningham. Like Representative Rorta, I served 8 years in this body, along with him actually, and in the Senate. I'm here to support Representative Wiemann's House Bill 238. When I did leave the Senate, I was elected to a board of directors of a local fire protection district. So we've been talking about local boards. Asked me any questions about it. And that local board was unionized. We are a taxing political subdivision that provides fire and emergency medical services. The reporting itemization of this bill are helpful not only to the taxpayers, but especially to the union members. I remember one day I asked one of our union firefighters what his dues were spent on. His answer? Probably bar bills. They don't tell us. In our district alone, in St. Louis County, those dues that our firefighters pay are $2,200 per firefighter per year. That produces, just in our little district, almost $500,000 every election cycle. From one fire district, there are 20 to 30 districts like mine in St. Louis County alone. Union members get no accounting whatsoever for those huge sums that they donate, and they deserve a report. With regard to reporting, remember, we're dealing with a taxpayer-supported government entity. Just like we as candidates have to report our personal financial and how we spend our money, this would do it likewise. Secondly, the bill provides for collective bargaining to be done in public. I'm hearing it thrown around that this is taking away collective bargaining rights. It does not at all. Our fire district started a couple years ago putting collective bargaining into the public, letting the public see. It's probably the only one anywhere that I know that does it. We were featured in the Show Me Institute article because of as an example of good government and transparency for doing this. It was interesting to me. Yes, taxpayers came to watch us. The press came to watch us. But the union members came to watch us. And that surprised me. But you know what? Not only the taxpayers have a stake in this process, but so do the union members. And they have a right to feel like their representatives are aggressively representing them. One thing I would add to this bill, and it's a priority item for me, and to the Paycheck Protection. As I said, we are an elected government board. We have absolutely no business collecting dues from our employees on behalf of an independent, as you said, outside organization, especially one that spends taxpayer funds on political campaigns to the taxpayer's interest. Permission is really irrelevant. Payroll deduction for private purposes is unethical, and it's not a legitimate function of government. Heck, they don't even pay us for doing their work. Private banks provide the same service, and any customers of theirs can deduct regular deductions to send to the union. Government should not be administering this union program, period. This approach would give union members control over their own payments when they feel like they're not getting deserved services. I've witnessed those situations where employees haven't, and they are helpless to stop those dues payments. Many people refer to the right to work legislation as worker freedom. I consider this worker protection. Now, I'm going to go off my script for one thing because I'm feeling like you all are not getting the picture of what goes on. I talked about that $500,000, $500,000 that is produced by these dues every 2 years. I want to tell you that after I left the Senate, I had represented this area where I ran for the fire board for 12 years. Typically, if you're running for a local government, school board or whatever, if you spend $5,000, you spent a lot. I spent $85,000 to get elected to my local fire board after I'd represented that area for 12 years. Why? Because they have $500,000. So local citizens can't even run for these fire boards. And you know what happens? We're not talking about collective bargaining that's fair. We're talking about collusion because the fire union owns both sides of the bargaining table. If they elect their own candidates that are supposed to represent the taxpayers and they are sitting there on the other side of the bargaining table, it's collusion. They are setting their own salaries and their own benefits. And I'll tell you what, you just need to see the whole picture. I've been there, I've done that. It's like an elected government and a shadow government, and they are very powerful. I'll take any questions. Thank you very much.
Thank you. It's good to see you in here.
It's good to be back.
And just so everyone knows, we're gonna open up questions from the committee, and then we have a hard break at 10, but we're going to go back in at 4 to resume the committee at 4 in hearing room 6. So with that, do we have questions for this witness? Representative Rowland,
To it, part, please.
proceed.
Senator, thank you for your service, and thank you for continuing your public service. I know that's difficult and it's challenging, and I admire you for doing that, so thank you. On this bill, to have a certification, they need 50%, is that correct?
I think so.
So would you be also willing to decertify the union to have the same standard, they would have 50% to all the voters in order to decertify the union?
Let me think about that and get back to you on that.
That'd be very fine, thank you very much. Also with regards to political activity, these labor unions do in fact involve in political activity.
Yes, they do, and I think that's inappropriate.
Okay.
There's even a bill that Eric Schmidt passed that allows a firefighter to run for fire board and actually be able to set their own salaries. That's a conflict of interest. But it's law.
Point. And if I'm correct, is it 504(3)Cs, is that right? That if they get involved in political activity, they have to actually, they don't, what I'm saying is there's a lot of
501c3s cannot be involved in political advocacy.
Okay, but if somebody in that realm, in that IRS statute, if they're involved in political advocacy, they can have donors that provide money to that organization, but never have to say who in fact gave that money. Is that correct?
That's election and campaign, law, and I'm sorry.
But what I'm saying is, you're saying from the labor union's perspective, to be able to give their money to political activities, they should be allowed to do that. But then we allow billionaires in this state that have given literally millions of dollars to this legislature and many people in this body, that in fact you're saying that that's okay, if I'm hearing you correctly.
I think everybody who donates ought to be disclosed. All of it should be disclosed.
Right, but my point is, you're saying that if I'm hearing you correctly, on the labor side of the equation, you have tremendous heartburn on that. But if a billionaire gives the money, you don't have the same heartburn.
I think they ought to be treated the same.
Okay, thank you, Madam Chair.
Thank you. Representative Miller?
To have a chat with Representative Rowland.
Proceed.
Although, let me go back to that. Sure. I guess what you need to see is the government process is being corrupted. When people who are employees can donate to who's going to be setting their own salaries, that's a corrupted system. And that's what we have right now.
Thank you. And to clarify something that was said to the senator. You had mentioned 30% and then 50%. Right. Okay. Actually, it's 30-50 for everything. To decertify, they just have to have notification of 30% of their members to have an election, and then it's an over 50% vote to decertify. Same with getting a union. They have 30% of their members say, hey, we want to be represented by a union, and then 50% or more must vote for that union to come in. So it's basically apples and apples of that.
And that was my question, and I appreciate it. Thank you, Representative.
Thank you. So we will break and we will come back, hearing room 6 at 4 p.m.